Welcome. This is the Faculty of Law, University of Lagos channel. From this channel, we intend to bring you lectures on different aspects of the law. In today's presentation, I will be taking you through the tort of nuisance. My name is Professor Oluwakemi Adekile. The structure of this presentation would first entail looking at learning outcomes. Now, let me explain the significance of having learning outcomes. As a student, learning outcomes help you to pick out those issues that your lecturers, your examiners, so that when you listen to a video or you read a material that has learning outcomes, you should go back to those learning outcomes and see if you actually understood those learning outcomes from what you have listened to. I also encourage students to carve out questions from their learning outcomes. You can actually turn your learning outcomes into questions. So today's presentation on tort of nuisance would have the following learning outcomes. First, you should be able to define private nuisance and give examples of private nuisance. You should also be able to define and explain the social context of the tort of nuisance. In other words, why do we have nuisance? Why does the law regulate the way we use and enjoy our property rights? You should be able to explain the elements of the tort of private nuisance. You should also be able to identify those who may sue and who may be sued in the tort of private nuisance. Understand and discuss the remedies, because the essence of law is that you have remedies that you can pursue, what you want to obtain, what you want, for instance, that the court should do for you. So what are the remedies that are available in private nuisance? And finally, a good student of this subject, of this topic, should be able to provide and explain and list the defenses available in an action in private nuisance. Now, what is a nuisance and what do we mean by private nuisance? Nuisance is twofold. You have the public nuisance and the private nuisance. Now, nuisance, I will just say simply, is an interference that meets certain conditions that the law has stipulated. And there have been many definitions given. Some of these definitions are context specific, looking at maybe it is private nuisance or public nuisance. When you talk about private nuisance, for instance, it's been said that this is an interference with another's use and enjoyment of land or rights appertinent to land, such as easements. Interference with another's use and enjoyment of land or rights appertinent to land. In Walter and Selfie, it was described as an inconvenience, materially interfering with the ordinary comfort physically of human existence, not merely according to the elegant or dainty modes of living, but according to sober and simple notion among English people. That's an English case. Of course, you can say among Nigerian people. And what that definition is saying is that where the interference must be such that is ordinary, it is not an interference. It should not be an interference that arises because a plaintiff has set a very high standard of living for themselves, in terms of expectation. As we go on, you would see that nuisance is context specific, society specific, even, in terms of what we can say is a nuisance or it's not a nuisance. You need to look at the environment within which the complaint is arising. So it says that's according to, it's just simple, the simple notion of what is acceptable way of using your property, of living. And when we are talking about nuisance, perhaps I should tell you that we're talking about things like, oh, I'm in my house and my neighbor is making so much noise, I cannot sleep. Or they are sometimes in Nigeria, people talk about people that maybe you are staying downstairs and your neighbor upstairs is pounding yam every night when you want to sleep. So you're talking about things like noise, like smoke, like fumes, like everything that causes an annoyance in the way you are able to enjoy your property. If your neighbor makes so much noise, for instance, every night, they are throwing a party every night and you're unable to sue, then you're saying, oh, there's very an interference with the way I use my land and I enjoy my property. So we have different forms that will be taken as time goes on. Now, when you're looking at private nuisance, you're talking about interference, not only just an interference, but what is regarded as unreasonable. It's what, because it's regarded as unreasonable, that it becomes a nuisance. So it's not all interference that will be regarded as a nuisance, but such as it is regarded as unreasonable. So your activity may be lawful, and that's why this law is very interesting, because what it does is that it tries to regulate the legitimate use of property. Most of the complaints about nuisance are legitimate use of property. Oh, I want to hold a party in my house. Oh, I'm cooking something and smoke is emanating. I'm keeping a poultry. So most of those things, there's nothing really inherently unlawful in them. It is the fact that it is unreasonable in the context in which it is done, probably because of the duration, or for whatever reason, or because there is malice. All these things, we'll be looking at them later. That's when you begin to say, oh, the way you have used your property is unreasonable, because it is an interference with how the other person is using their property. So when you look at that description, you can see that this is not a tort where A goes into B's land directly, unlike what you have under trespass to land, for instance, but rather that by virtue of what you are doing on your own property, without going or looking at the next person, it is affecting the interest of your neighbor in using and enjoying their property. Private nuisance could also be where you have physical damage to property. Now, the interest that is protected, therefore, is the interest in the use and enjoyment of land or rights that are pertinent to land. Your interest in using your land. I am not able to sleep because there is so much noise from my neighbor, and that noise is unreasonable. Then we say there's been an interference. Now, the context, therefore, is that the law tries to balance the legitimate use of property by two property owners. In most cases, private nuisance deals with intangible invasions. Like I've talked about noise, I've talked about smoke, a smell, things that are not tangible. Because later we'll be dealing with comparing nuisance, for instance, with relevance and Fletcher, with negligence and what have you. But in most cases, not exclusively, mind you, private nuisance deals with intangible invasions. Dust, vibrations, things that you cannot actually hold in your hand, but their occurrence is causing an infringement on the right of the other person to use and enjoy their property. Another point that I should make at the beginning is that for something to constitute a nuisance is usually a continuing state of affairs, and a state of affairs that is going on for a period of time, and the plaintiff is coming to seek for an injunction to stop it. So that is not to exclude the fact that occasionally you have one-off events, but somebody is playing music repeatedly every night, or is as a club or near your building, things that happen repeatedly and continuously usually constitutes private nuisance. I must also emphasize the fact that you recall from your knowledge of the tort of negligence that we talk about remoteness of damage. Yes, you must have damage, but the damage itself should not be too remote, too far-fetched from the risk, from the incident that has occurred. So you do not, and we talk about reasonable foreseeability. So the tort of nuisance is also subject to the rules of remoteness of damage. The plaintiff must suffer actual damage, because unlike trespass to land, private nuisance is not actionable per se. It is not actionable per se. But we will talk about the context in which some of these damages would be presumed. What are the elements of private nuisance? You know that most torts, you deal with elements. After you have defined your tort, you should be able to determine what are the elements of that tort. With regards to private nuisance, we'll be looking at the fact that, one, there is an interference with use and enjoyment of land or rights appertinent to land. Second, that the interference is unreasonable. You're talking about the behavior of a defendant in the way they have used their property. It's unreasonable. So the meaning of unreasonable would be looked at. Then we have said that the plaintiff must suffer harm. It is not actionable per se. Interference with land means either that there is sensible damage to property. For instance, that a building has cracked because of the vibrations that had taken place from the property of the defendant is a damage to property. So it could be sensible material damage to property or substantial interference with use and enjoyment of land. Like I said earlier, the fact that somebody is keeping a poultry and every time at a particular hour of the morning when you are still sleeping, you find out that that's when the chicken wake up and they make so much noise. Or somebody keeps dogs and the dogs are barking all night every day and you're unable to sleep. Or somebody is keeping snakes, or or somebody's vegetation, they left their property unkept, and then it creates a nuisance in terms of having rats or rodents or escaping from their land and onto another person's land. These are some of the things we are talking about. Interfering. So you are disturbed as a plaintiff on your own property. He has not come to your property. The person has not come to your property to do anything. So you're not talking about trespass to land. But what is happening on their property is affecting the way you enjoy your own property. So you have examples, like I said, noise, flood, dust, vibrations, and what have you. One of the fundamental principles of the tort of private nuisance is that the plaintiff who is seeking a redress must have an interest in land. Because I sometimes describe private nuisance as a tort, of social relations. Talk that regulates good neighborliness. You can't just do something because I have a right to do it on my own property. I must consider the interests of other property owners, my neighbors in the building, on the street. Am I disturbing them in the way that I'm performing what I'm doing, my act, or making my own, or living my life? In Malone and Lasky, it's been held that plaintiff must have an interest in land, either as an owner or occupier of property. The nuisance itself must not be trifling or merely minimal. It must actually affect the value of the property. There are some nuisances that are not actionable. There are some state of affairs that are not regarded as nuisance, if I can put it the other way. Interference with light is not redressable as private nuisance. Interference with TV signal, very popular case of Hunter and Canary Wharf. Take note of that case, that where the plaintiffs had complained that the installation of a tower interfered with the reception of with their TV signals. The court held that was not an actionable nuisance, that interference cannot be of things of delight. That was in 1997. And you might wonder whether that same decision will hold today with technology, with all sorts of needs in terms of connection to network. Then it's also held that only those with interest in land can sue in private nuisance. So if you don't have an interest in land, for instance, perhaps you are living with your parents, your dad is the owner of the house or is the tenant in the house. You, as someone living with him, maybe as a child or nephew you cannot bring an action in private nuisance. It must be that you have an interest in land. Even the wife of the person that has an interest in land cannot bring an action in private nuisance. Then so we have interference with a view as well. Those three situations are not actionable as nuisance. Now, I said earlier that it's not sufficient that to say the defendant's activities constitutes an interference with my use and enjoyment of land. It must be determined that the interference is unreasonable. It is unreasonable. And what do we mean by unreasonable? In Cambridge and Water Works and Eastern Counties Limited, it was held that if land is used unreasonably and the damage is reasonably foreseeable, the defendant will be liable. But if it's not reasonably foreseeable, the defendant will not be liable. So reasonable foreseeability is also important in nuisance, because that's what makes you to know that the actions of the defendant are unreasonable. If I decide to throw a wild party in my flat all night, every day of the week, I think it is reasonably foreseeable that my neighbors will not be able to sleep. That being foreseeable shows that my action is unreasonable. is unreasonable. In order to understand the meaning of unreasonableness, the courts have developed some principles to assist in the determination of the cases. Some of these principles are: they look at the duration and time, they look at the locality, they look at abnormal sensitivity of the plaintiff, they look at malice, they look at utility, and they look at reasonable foreseeability. Now, duration and time. It has been held that the concept of duration relates to the interference that the action of the defendant causes. What kind of interference does it cause? And generally, the longer the activity, the longer the interference lasts, the greater the likelihood that it's regarded as unreasonable. If somebody holds a party, a birthday party, just one day on a Saturday, and there is noise around just for a day, that may not necessarily be regarded as unreasonable. Okay, but when somebody does that repeatedly every day, or has a club or a brothel around, and there are continuous noise in, if other contexts are in place, the court may likely hold that there has been unreasonable use of that person's land. So the longer the nuisance lasts, the greater the interference, and the greater the likelihood of it being held to be an unlawful interference. Then you have the case of Crown River Crisis against Kimballton Fireworks, where fireworks that were lighted by the defendants that destroyed the canoes of the plaintiff were held to be unreasonable. That was a one-off event, actually, and the court still held that this was a case of nuisance. So while generally nuisance is a continuous state of affairs, a one-off event sometimes could constitute a nuisance, and that's where you may have to be very careful about the relationship of nuisance with Rylance and Fletcher. Now, the case of Alcy against Esso Petroleum also held that private nuisance is more likely at night when people are trying to sleep. It's more likely at night. Activities that are taking place at night are more likely to constitute a nuisance than during the day, when people, the tolerance level for noise is higher. Then locality. Locality relates to character of the neighborhood, of the area that is in question. The kind of area you live in may determine whether what is being done there is a nuisance or not. And that's what helps to determine reasonableness at times. Okay. For instance, in Sturgis and Bridgman, a doctor was disturbed by the confessionals machinery in a residential area, was held entitled to an action in nuisance. And Lord Tizia stated there that what would be a nuisance in Belgrade Square would not necessarily be a nuisance in Badmonsi, meaning that you look at the locality. Let's take in the context of Nigeria. And that same quote, a similar statement was given in Tebite against Nigeria Marine and Trading Company, where it was said that what is a nuisance in Ikoyi will not be a nuisance in Ebute Metta, telling you that, okay, what somebody in Ebute Metta will tolerate is different from what somebody in Ikoyi will tolerate. That is why you see that the value of properties are different. They are all maybe a block of flats, the building materials may be the same and whatever, but the location will determine whether what rent you pay or how much you pay for that property, because it is expected that if I'm living in Ikoyi, I'm living in Banana Island, I'm living in Lekki, I expect some measure of comfort that is higher than what is expected of someone that is living in Mushin or living in Oyigbo. Okay, so those are the parameters, some of the parameters for determining whether something is a nuisance. And in Heroes Electrical and Peak Ingredients, for instance, where the parties were located in an industrial area, the Heroes manufacturing company was manufacturing mobile phones, while the defendant, Peak Industries, was dealing with curry. He produced curry, and the curry smell permeated the environment, all the time. So Heroes found this objectionable, and they sued in private nuisance. And the court held that the character of a neighborhood affects whether it is a nuisance. And when you are in an industrial area, in an industrial estate, you must expect some noise, some smells, some fumes, rather than when you are in a residential area. So if nobody, for instance, you are trying to get accommodation, you would not necessarily want to go and take up accommodation in an industrial area. Then abnormal sensitivity. Abnormal sensitivity relates to the fact that if a plaintiff is unduly sensitive, you are just too sensitive to what is being regarded as nuisance, the court may not determine it as unreasonable. The major case there is Robinson and Clivert, where the plaintiff was keeping special paper and it was damaged, by activities from the defendant's land. The court said that those papers were special paper. Ordinary paper would not have been destroyed. So that's an instance of abnormal sensitivity. Another thing that could determine unreasonableness is utility, the purpose of the activity. If it's a beneficial activity to the society, to the environment, it may weigh in the mind of the court as to whether it should be regarded as unreasonable or not. And you can see in that context the case of Miller and Jackson. And you also have malice. This is quite interesting. Where you have a legitimate right to do something, but you do it maliciously, there's the possibility that the court will hold it to be unreasonable. And you have a lot of cases there. You have Hollywood, Silver Fox Farms against Emmett. You have Christie and Davy. You have Moore and Inando. In these cases, what the defendants did was done out of malice. For instance, in Christie and Davy, because the defendant did not like the music lessons that was taking place in the plaintiff's residence, he began to burn trays on the dividing wall, and the court held that constituted a nuisance. The other factor is reasonable foreseeability, which I mentioned briefly before, that where the damage is reasonably foreseeable, then the court is likely to hold that it is an unreasonable activity. You might see the case of Wagon Man #1 and Malone and Lasky in that context. And very significantly, I want you to see the case of Cambridge Water Works against Eastern Counties, where the court actually clarified the position of the test of foreseeability in the cases of nuisance. And so the third element of private nuisance is the fact that damage must occur. The defendant in the private nuisance action must be able to show that they have suffered some damage, because nuisance is not actionable per se. And you know the meaning of not being actionable per se. This may be physical damage to property, it may be loss of amenity like unable to sleep, breathing issue, damage to chattel on the property, to vegetation. These are some of the examples of the kind of damage that you find in private nuisance. But there are situations where you don't need to prove damage, where the court can presume, for instance, that damage has occurred. The facts can show that there is damage. 2, where the interference is with an easement or right of access to which plaintiff is entitled. Or thirdly, where you are asking for a quiet injunction, an injunction to restrain an action that is not yet taking place, but you can foresee that it may cause damage. In this context, you say that damage need not be proved expressly. We have said earlier, the person can sue must be someone that has an interest in land. See, in this respect, Malone and Lasky and the case of Hunter and Canary Wharf Limited, which has been clearly established in today's context. The people that can be sued, for you to sue someone, I think like it's easy to know that the person that creates the nuisance, you can sue that person. You may sue that person alone or in conjunction with any other person. You can also sue the occupier of the land, and you can sue the landlord. Now, the creator of the nuisance is the person who creates the nuisance, the creator of the nuisance. And that person always remains liable, whether you are going to make him a joint tortfeasor with others, maybe the person that authorized him to commit the act of nuisance, for instance. Then you occupier of land where the nuisance emanates. For instance, if a defendant had failed to clean up his environment and overgrown weeds has caused snails and rats to come onto the property, in that context, you can sue the occupier, the person living on the premises. Okay, and in most cases of nuisance, the occupier of that premises is also the creator of the nuisance. But in some cases, the occupier is not the creator and is still liable. He's not the one. He's the occupier of the premises. He's not the one that created the nuisance. As many as somebody comes into his land and is burning bush every day, and the smoke is disturbing people in the neighborhood. So in that context, the occupier maybe it is the servant of the occupier who is acting in the course of his employment or employer's liability. So in that context, you can sue the occupier together with the person who created the nuisance. You also may sue the creator, where the occupier, where the creator of the nuisance is an independent contractor engaged to do extra hazardous activities. In that case, you can sue the creator of the nuisance and join the occupier with it. Third, you can also sue the occupier where the creator of the nuisance is a licensee of the occupier. I mentioned earlier, for instance, is the child of the occupier the wife, a lodger, a guest, a visiting relation living in his house? You sue the occupier of the premises because of that state of affairs. Or where the occupier knew of the nuisance or ought to have known of the nuisance and he failed to abate the nuisance, then he is said to have adopted the nuisance. Then where the nuisance was already on the premises before the occupier got there, the occupier knew that the nuisance is there and does nothing about it. Maybe he met a very bushy compound. He was not the one that made it like that, and then he failed to abate it. In these situations, you may sue the occupier. Then you may sue the landlord. The occupier is usually, let's say, somebody like a tenant living in the premises. Then you can have a situation where you sue the landlord, the person that puts the occupier there. That would also be possible in some cases. But I must say that generally, the landlord is not liable. But it would be liable if the nuisance arises first from want of repairs and he has covenanted to repair. Okay, if the landlord is not liable, he is not usually liable. Let me repeat that. Generally, is not liable. Okay, where the nuisance did not arise from lack of repair, where the tenant has covenanted that will repair the premises. A nuisance that deals with repair of premises, and where the nuisance arose by act of God, or where the nuisance was by act of a trespasser or a latent defect. In this context, the landlord generally is not liable. However, the landlord may be liable where he authorized the nuisance, where he has given the landlord permission to do something that constitutes the nuisance, or where he has covenanted to repair and the nuisance arose out of repair, or where the landlord himself created the nuisance. So these are some of the contexts in which you have someone, these are some of the people that can be sued or be sued in private nuisance. So in summary, therefore, the tort of private nuisance regulates the activities of two property owners. You must have an interest in land to sue, and it is a way that the law ensures that how you use your property does not negatively affect the interest of others in using their property. Thank you for listening. I will see you at the next presentation.